new changes in the laws, and I look at it more from the point of view of a small startup, a company, or companies I'm involved in helping out with, but also my own company. I have 23 patents that I'm an inventor on, and have done a lot of work in that area. So what you see there is what's really happening. It's an overhaul, but it's somewhat destructive overhaul from our perspective in terms of the patent law. So that's happening, and we hope that a lot will actually remain intact, but it doesn't look like it's moving in that direction. There's the issue of the First-to-File in the AIA, the America Invent Act, effective elimination of the grace period. There is a grace period, but it's not really certain and secure. You almost have to assume it doesn't really exist for all practical purposes. There is a broad expansion of prior user rights. Somebody who's used in a certain invention and never published it, never revealed it, hoarded a secret, may be protected. Now they're not. There are administrative areas of support to large companies who may want to seek patent application. They can't get a hold of their inventors or something, and they can now file an oath and declaration in lieu of that of the inventor under certain circumstances. There's a post-grant review proceedings, and that is the ability of third parties to challenge your patent once it's issued, and that the rules for that will issue this week or next week, and will be in effect in September next month for that. And that's something to deal with. There's also supplemental examination and pre-issuance submissions by third parties, means of allowing people to present prior art for patents that they've seen or application they've seen, and help the examiner essentially discover these things, or if he doesn't on his own. There's also a whole change of fees, and that's going to affect your fees in terms of the patent application fees and maintenance fees. And those are sizable increases. The Patent Office made a proposal last February. The rules are still not out. We'll see what they come out to be. There's also a micro-entity concept. A lot of you would be interested in that, and that is an additional halving of the price or the cost of fees. So if you're used to a small entity fee, now there's a micro-entity fee, which will be 25% of the normal fee. But don't hold your breath, because at the same time the Patent Office is going to increase all the fees. So by the time you're done, I've done a calculation, you'll find that a typical application for a micro-entity fee wouldn't be that much lower than what it is. The small entity fee today, it will be only 9% lower than small entity fees on average. Again, if the Patent Office comes with actually different fees that they propose, it will be probably better. What I'll talk about is how our current practice in practicing these things and filing applications and developing technology may have to change. And also going to reevaluate the trade-off between patenting and trade secret protection, particularly. So I'm discussing here pretty much the utility patent applications, not getting into designs or the trademark and copyrights, but utility patent applications. And consider various defensive ways of working through the practice. First-to-file is obviously the first major reason for the change in the AIA. Companies who wanted this to happen, that was the central goal. They wanted to make the system look like what it is in Europe. In the process of doing that, it didn't really come out like that. It was different. So now you have a system still that is different, not harmonized, but nevertheless, it is based on filing date rather than invention date priority. The problem is that for 20 years, we will have two patent systems in operation. All the patents, all the inventions, all the filings that occur before March 16, 2013 will enjoy the old patent law, where the first to invent rules operate, including definition of prior art and things like that. But the new systems, all new applications filed after March 2013, will then be governed by the new First-to-File laws. And so you have two systems. You almost have two classes of patents: the good patents, the old law patents, and the not so good patents in terms of value, ability to protect, and so on. So that's an important point. You'll have two systems in the works, and the courts will have to deal with two systems. People would have to deal with two systems for 20 years. So for your lifetime as an inventor, hopefully you probably will be longer, this will be a major bifurcation, a major barrier. So the part about the first-to-file and priority and so on is Section 102 and 103, and it basically moves it from a invention date to a filing date based system. The first-to-file per se, just competing on who filed first, is not the issue. The issue is what is the prior art compared to your invention date or filing date. Interferences, these are the disputes among those who come to the patent office nearly at the same time claiming the same invention, are very rare. There's only 50 of those per year out of 400 and some thousand applications. So that is a red herring. The issue is that the first-to-file, don't think about it as a first-to-file issue in terms of contest, but think about it as a filing date compared to prior art, compared to things that happen elsewhere. And that's more common and more problematic. And the result of that is that the grace period is essentially eliminated because it basically gives you grace only if you've disclosed publicly the information, and then it has to be an enabling disclosure. I'll talk about it later. Now, there's no interference. There's no contest to who invented first, because the invention date is no longer an issue. It's the filing date that counts. But Congress still wanted to protect theft of inventions by others, and they put a system called the derivation proceeding, which will replace interferences. In other words, you'd have to say, it's not a matter I invented first, but he didn't invent this, he derived it from my invention, therefore he's not entitled to that patent. That's called a derivation proceeding. Derivation proceedings actually exist even today under interferences, but they're not common in every interference. The filing date priority is based on the following change. The current law says that the invention, you're not entitled to a patent, you are entitled to a patent unless the invention was patented, described in printed publication in this or a foreign country, in public use or on sale in this country. Okay? More than 1 year. So you had the year of grace before your filing application. The AIA says no such thing as 1 year, but also it adds another term called otherwise available to the public. Now that's a new term. So on sale, public use, patent application, otherwise available to the public before the filing date, the effective filing date. So now it's no longer the invention. That is a major change, okay? Do we know what some of these terms mean after this change? No. There's a lot of confusion or at least disagreement on the interpretation of it. Now, there is an exception for this. So this says, look, anything you do, you better file your application before it's public, before you go to a trade show, before you offer it for sale, or before you even buy it from a subcontractor who's selling it to you. Remember, sale of the invention doesn't mean you, the inventor, selling it. It could be a vendor building your prototype, selling you back that prototype, and that's been deemed as a sale of the invention, if there's a commercial aspect to it. So anybody who's using prototypes, subcontractors, have to be very careful. Make sure you have filed a patent application before a contract to make your prototype is done. Now, some of the chip companies have been concerned about this, because any tape out going out to large volumes of chips being made and pilot production is an issue. Now, if you're doing experimental work internally and you don't disclose it, and you still use a contract for that's not a bar. But if the pilot production is intended to be sold commercially, and is sold commercially, then you have an issue. What is different now is that you used to have a concept of a loss of a right to patent. So sometimes you would, today, under today's law, there are situations where it doesn't matter if there was prior art or information. If you just waited too long after your invention and you didn't file or reduced it to practice to file the application, if you exploited commercially an invention and exploited commercially in secret, so maybe you had a special process, manufacturing process, you did it, you used it, nobody saw it, nobody knows what it is, but you're benefiting from it, that's commercial or secret commercialization, then under current law, if you hadn't filed after a year, you would lose your right to a patent. Some people read this language as saying you don't have that bar anymore. You can use commercial ideas that you might have used for 3 or 4, 10 years. As long as there's no public information on it, as long as it's not prior art, you can still file a patent application after 10 years. Okay? That is not something that everybody reads in the AIA, but some argue that it's there. The exception is only if you disclosed yourself as the inventor, and then you have a year. But then that disclosure has to be fully enabling of the invention, of the claims you obtain, and so there's some risk. Also, somebody else can see your disclosure and then publish something else, perhaps a species that you haven't disclosed, and say, oh, I got this now, and that's in between your filing date, and you have a problem. So be very cautious about assuming that there's a grace period. In fact, a lot of investors who are now talking to companies want to understand that they haven't really availed themselves of a theoretical grace period, or will be doing that. And so you'll be well advised to assume that, in fact, you probably don't want to disclose. If you're ready to file, just go ahead and file the application. There's a new risk now coming up with this new law. I call it the false patents risk. Remember, now invention doesn't matter. Who invented first doesn't matter. What matters only what's the public domain, what's in the public domain, what's published. You can have a patent, a filer A, maybe it's you, okay? And you going through the process, you filed it first. Doesn't matter when you invent it. But you're going on a slow track. You're Adrian. It takes you 8 years to get a patent out, okay? And it's not his fault. It's the examiner's core or the backlog of the PTO's fault. But you have decided to keep your invention confidential. You have a right under Section 122 to elect to prosecute your invention in secret. So it doesn't publish until you actually get a patent. Because guess what? If you don't get a patent, you may not want to publish it. You want to keep it as a trade secret. Some people do that. There are about 10% of patent applicants, which is more high percentage when you talk about U.S. applicants, who elect to prosecute their patent applications in secret. It's a negative option. You actually have to ask the patent office not to publish it. If you don't, it will be published 18 months after your filing date. Well, suppose A has got that type of an application. And then B came out and filed later and got an issued patent. Maybe he even used the accelerated examination process. When that patent issues at this time, when the examiner looks at this, even if he knows about this sitting in the patent office, he can't use it to say you have an invalid application. He has to issue your patent. There's no procedure now under the first to file unless there is a publication of the information. In other words, because this is not published, not available, he can't say that you're not entitled. B is entitled to a patent. So B will get a patent, and during that period until yours is issued, when yours is issued, then you can say, look, I'm first to file, here's my patent, and now it's published. You can invalidate that of B, okay? But until such time that that happens, you're stuck. He may actually sue you for infringing. And your only option would be that, okay, I'm going to publish my application. Can force you to publish it so that you can validate his patent. So that doesn't exist today in today's laws. Yeah.
Just real quick, that scenario won't exist until March next year,
Correct. Correct. And so this would be there if only after March 2003 for those types of applications. Now, it's a little more complicated if one of them, one of them is before 2013. It doesn't matter. It's the patent that counts. This one. Now, this was filed after 2003. It cannot be used to invalidate it. Now, how many of those occurrences will happen? It depends. Remember, it's not just whether it's the exact same invention. It could be just an obviousness argument that says it would, patent B is not entitled to a patent because there's some obviousness that even though A doesn't teach the same thing, it will be obvious over A. So it could have quite a few of those. It will be more of those if B is coming through this accelerated examination process, which could take less than a year. In other words, people can actually file for a patent application and get a patent within a year, and they have to pay more, and I'll talk about it if I have time. So, next item. The ambiguity in the AIA has to do with the grace period, and like I said, what is the public use, what the on sale, otherwise available to the public. Courts have already resolved what the meaning of on sale and public use is. It's a very well understood area. There's over 600 cases in about 150 years of case law. There are other problems with reading it. This just shows an example of Supreme Court decisions about the public use and on sale. And it was major changes occurring in the 1839 Act and 1870 Act. It took about 20 years before the law and that meaning of those terms has been resolved by the Supreme Court. Okay? So expect the AIA's interpretation and the courts to deal with it for probably 2 decades in terms of what it really means. It's got to go through the lower courts, the Federal Circuit, the Supreme Court, and there are very aspects of it that have to be resolved. So hold your breath. Not. Okay, so let me just move on to fundamental.
Creating jobs, right?
Yeah. Right. Prior user right. The prior user right is a new right for those who use the inventions or the technology in private and earlier than the application, and now they'll be able to defend from infringement. So if you can prove that you've used something secretly on your own for commercial purposes more than a year before the application of the guy who has the patent, you have a defense. This doesn't exist today. Okay? That's called a prior user right, and it's part of the law here. I'm going to skip a lot of these graphics. They're very cool things for engineers, but I'll just, in interest of time, go into the process of what we're dealing with here. Skip one of these.
Will this presentation be available to us in any form?
I will. I'll make it. Yeah, I'll make it available. So a quick point on this one. Normally, in the development system that we have today, this is an example of my company, what we do. An example, we do some concepts. We have an invention. We have a system design. Then we have a particular hardware, software design, and FPGA design in this case of electronics. Prototype, modify, and then do it. We typically then file an application at this point because we have the design. We know, we actually have reduced it to practice. We know what to write in the patent application. We know what the claims are. And then we go through a demo and maybe another patent application once we've tested it and done more things. So that's kind of what happens. Under the first to file, though, with no grace period, in every step of the way you have to consider filing an application. Why? Remember, it's the filing date that counts. You can't reach back to a conception date. Right? So you have ideas, maybe 4 ideas. They're not sure which one works. It will take you time to evaluate and to figure out that only one actually works. Well, you may have to file multiple applications here. Okay? Otherwise, you might lose some time, maybe 6 months, maybe 8 months, depending on your development time, exploration time. You got a system design. Now you've got an enabling structure. You can say, look, I have a design. I'm going to file it. It's got more support for claims. I'll file here. Same thing here. And so you basically end up potentially having to file more of these applications. Redefines the prior art and requires R&D planning because of this issue. Timing of pilot production, I talked about it. If you have an external system, I'm going to skip this. But here's what happened in Canada. When they moved to the Firsttofile in Canada, look what happened to people like you, individual inventors. In 1989, Canada switched to Firsttofile. This shows the relative or the fraction of patents issued to individual inventors in Canada versus everything else, corporate. A decline of 26% in the share of patents issued to individual inventors at the time after the Firsttofile. What does that mean? Probably couldn't really file all these many applications we talked about. Maybe there's some other impediments, other risks, and maybe they decided just to go trade secrets. It's more costly for small businesses and the inventors, and that could happen. So brace yourself. You'd have to go through the process. I'm going to skip a lot of the statistics of what happens with the Firsttofile. Some myth. Does the AIA eliminate the need for first inventor determination? No. In every derivation, you have to see who's invented first, because in derivation, you have to decide which inventor conceived it first and then communicate it to the other one. So resolving derivation requires a determination of first inventor. Also, in every case of prior use, you also have to find out, did he invent first and then used it commercially first? So it's a myth. Don't believe people who tell you, oh, now I don't need to keep records of first invention and so on. March 15 deadline, a day before the 2013 deadline for Firsttofile. This is important to figure out what it really means for you. The pre-AIA priority for continuation and divisions effectively eliminated. This is a very deliberate process where the PTO actually made the change, offered the change in the law, such that if you have pending applications that have a priority date before March 15, 2013, you would basically have a very tough time keeping the chain of continuity to claim priority to an earlier application. Firsttofile becomes a reality on this date, and it's applicable only except for application that all the claims substantially entitled to the earlier priority. The minute you have one claim that is amended and the examiner tells you it's not entitled to the priority of the original application because you didn't disclose something, it's only in your second date, the whole chain is tainted and you're no longer able to claim priority from the first date. What this means, you have to really be cautious. It is imperative that where possible, all applications which are expected to be prosecuted to a conclusion should have an actual filing date not later than March 15th. So if you have any applications that you thought, oh, I'll find divisions later on, I know I need more claims, I'm going to file continuations, make sure you file them before March 15th. There'll be a blip. There'll be a big blip. A lot of people will file before that. The old date best assures that the application will fall under the current first inventor regime and otherwise avoid the broadened definition of prior art. Okay, that's more valuable. Myth. Under FTF, inventions would not have to be kept corroborated invention records. We talked about it. Derivation, you have to prove it. Another myth, the Firsttofile can be solved by filing more provisional applications. Provisional applications aren't really different than normal applications. You still need as much support as you can. And you know, don't think that it will solve your issues. You'd have to have good application, including all the support. New procedures. What? Provisionals with no claims approach. If you haven't thought about the claims, do the provisional and you just file it, may not be as protective of your invention because you may not be able to essentially cover that. The thing is to really think about a provisional as a way of saving money, but not as a way of saving the amount of stuff you have to put in the application.
The provisional has to teach the art. You have to, in your provisional, explain what it is doing.
Right.
I've explained some of you with some of the simpler ideas can do it in just the abstract, because you could, in 2 paragraphs, explain the entire invention in just 2 paragraphs. However, something more complex, all of the claims are described in the provisional.
Yeah, you have to have support. Now, what does that mean practically? And this is the last set of conclusions. You will need to do periodic reviews, perhaps more often than you do now, because you might want to file. Employee exit procedures. If you have employees, you want to make sure if he goes to, when he leaves, you better file for an application of what he did, because he may file it somewhere else. Invention records mean nothing in terms of date, filing date. You have to reassess protection in terms of a trade secret, because a lot of times you might find that may be a better deal now, especially because of prior user rights and some of the risks of first to file. Does anybody actually have a procedure for identifying and what they do as a trade secret? It designated so and keeps a record of it and has procedure to protect trade secret. You want to make sure you have done that and you understand. That's a lot of state law issues, but you want to do that. Last item, workflow, delays in filing. Now your attorney is probably going to ask you to give him more in writing. Why? He doesn't want to keep it in his office. The clock is ticking for first to file, and he's going to write it down. He's going to ask you to do a lot. Who has got the time to do this? You expect that the responsibility means to fall on you a little more. Patent attorneys will ask you to write more of the stuff, so they'll have less time to deal with it and file your application. And it's actually a good thing that you actually have to write something to do that. A lower expectation, you will probably not get as many patents per application that you file under the new law. There are many other ways to trip, to fall, and not to get a patent. But that's an issue. Also, you may not have the full enabling disclosure at the time you file it. It may only be later. You have to make tough decisions. Am I going to drop this one, abandon this application because it doesn't teach all the things that I now learned and filed again? And so that's another issue. Inventor ownership is the last item.
Last item.
Yeah, the last of the last.
There's another one.
Check the USPTO database, because your application may actually show up there without you knowing. Why? Because some employers or your clients who hired you to do certain things said they couldn't find you to sign an oath and declaration, and they filed on your behalf. Okay? They can do it now, okay? And non-inventors can actually do that. And so that's important. The other reason you want to check to see if somebody derives something for you. All of a sudden there's a published application of your own invention, and you didn't know about it. You worked with somebody and derived it. You only have a year to figure it out. So if you find out about it 2 years later,
You missed your window.
missed your window. Vigilance is going to be important. It doesn't exist today. You can file interference and these
That's why
things.
it's very important for you to know your classification codes for your products, because if you know that, then you can keep searching under that database and finding out what's relevant in your classification. Stay on top of it. Ladies and gentlemen,
Great.
Ron
Thank you.
Kasnelson.